I'm City and State reporter Serena Triangle, and I'm here with City Councilman Ritchie Torres today. Welcome.
It's an honor to be here.
Thanks for joining us. So last week you highlighted legislation you and Councilman Daniel Garodnick will be introducing related to civil forfeiture, which is when police seize property but no charges are brought, and then ultimately an owner would need to go through the civil forfeiture proceedings to get it back. And it sounds like you're looking for more information about how this works right now.
Right.
So what do you know and what are you looking to know related to this?
Well, I mean, the point of the legislation is to, lift the veil of secrecy around a process that probably most New Yorkers have never heard of, civil forfeiture. Keep in mind that there are three categories of property seizures by the government. You have properties held for safekeeping, properties held as arrest evidence, and properties held for forfeiture. And of those three categories, the one that concerns me the most is forfeiture because it lends itself to the most abuse. So civil forfeiture is a civil case apart from a criminal case. And under civil forfeiture, the government can seize your property irrespective of whether you were convicted of a crime, irrespective of whether you even committed a crime. And the process of fighting a forfeiture action is so complicated and so cumbersome that you effectively need an attorney. And if you can afford an attorney, then you have the legal means of retrieving your own property. But if you cannot afford an attorney, then you essentially have no ability to vindicate your own Fifth Amendment right to private property. And so the core problem with civil forfeiture is that it penalizes poverty. It essentially attaches a price tag to property rights, and that price is prohibitive for those who cannot afford legal counsel.
And what are some of the major questions you'd like to know more about? What sort of information are you seeking?
I mean, the kind of properties that we're seizing, the status of those properties, the dollar value of those properties, the vouchers that have been handed out to those seeking retrieval of their property. So far we have no information at all. And the point of the legislation is to start a long overdue conversation about the property rights of low-income New Yorkers and to establish a principle of civil forfeiture reform right here in New York City. It's been a subject of national conversation. It's a bipartisan cause that commands support from progressive Democrats and libertarian Republicans, both of whom have concerns about the infringement of property rights at the hands of local, state, and federal governments.
And given what you know, which I gather is not as much as you'd like, what's your sense of when civil forfeiture makes sense as a policy and when it doesn't?
Look, I want to be careful not to suggest that civil forfeiture is inherently abusive. It depends on the application. And that's why there's a value to greater transparency. We have seen some reforms around civil forfeiture at the federal level. Before his departure, the former Attorney General Eric Holder did introduce a general ban on civil forfeiture. So before the reform, under the equitable sharing program, a local police department or state enforcement agency could seize your property and then ask the federal government to pursue a forfeiture under federal law. And this was not only a problem for property rights, it was a problem for federalism as well, because even if you had a state that imposed limits on civil forfeiture, you could have a local police department that could circumvent those limits by asking the Justice Department to pursue the forfeiture on its behalf. So ever since the reforms were put in place, there is now a general ban on federal adoption of property seized by local enforcement agencies. But there are two exceptions. So one is property that directly relates to public safety, ammunition, child pornography, instrumentalities, explosives. And then the second is property seized by joint task forces, like the DEA and the NYPD.
Okay, gotcha.
So there's been improvement. But what we're pushing for is greater transparency at the local level.
And this may be one of several legislative pushes that are not warmly received by the NYPD commissioner that you've been involved with. I know last week he described some of this as the fruit of novice city council members, and you
who lack private sector experience. Right?
Okay, and you responded essentially by saying, you believe he behaves more like an elected official than like a commissioner, and there's really very little interference in what he does from City Hall. Why does this matter, and what's the issue that this poses from your point of view?
Well, look, I thought the commissioner's comments were despicably elitist. I was personally offended by them. And the commissioner has every right to express his opinion on matters of policing. He has every right to defend what he sees as his prerogatives as commissioner under state law and under the charter. but he has absolutely no right to disparage and disrespect the city council. That oversteps the line. And the fundamental problem here is that you have a commissioner who feels empowered to say and do whatever he wishes, even if it means undercutting the mayor, as he did with his latest comments about homelessness, or his comments about the pedestrian plaza in Times Square, or his comments about the Moynihan report. I mean, there's a pattern of rhetorical recklessness, and that pattern will persist as long as he feels emboldened.
And
again, he's not the only commissioner who feels annoyed by the city council.
Right,
but he's the only commissioner who feels the need to publicly disparage the city council. So there's a double standard, right? There's a set of rules that apply to Bill Bratton, and then there are the rules that apply to everyone else. And I feel like it's in the best interest of our city if we dispense with that double standard. So.
And I guess in terms of sort of the average New York City resident, what do you think having an empowered commissioner might mean for his or her life, these people? Why should they care about this?
Why should we care? I think it's important to have respect for our democratic institutions. I mean, ultimately, a commissioner is an unelected bureaucrat and should show some measure of respect for those of us who are elected, irrespective of whether we have private sector experience, even irrespective of whether we're novices. When you are an elected representative of 165,000 residents, that should command some measure of respect from agency heads. I just see it as professionalism, and I think a commissioner, the job, Bill Bratton is not your conventional police commissioner. I sometimes feel he's a public relations firm with a police department, but his core job should be to manage the day-to-day operations of the NYPD. He should leave the politics of the politicians. He should leave the social commentary to the talk radio host and the columnist and the TV commentators.
Do you think this has an impact on how policy is decided or implemented?
Yes. I mean, as I've said to the Wall Street Journal, not a single piece of police reform legislation has been enacted over his objections, despite the extraordinary momentum from prior events. So he is a formidable obstacle to enacting police reform legislation. But again, I would never begrudge him his right to have his opinions and to advocate for what he sincerely believes is the best. But I believe we can have a constructive debate. And I resent the notion that my opinions are invalid, not because of the arguments that I make, but because of who I am, where I come from, and my lack of private sector experience. It seems like in Bill Bratton's world, Wall Street bankers have greater moral authority on policy questions like policing than the elected representatives of the urban poor. And that's not terribly progressive. That's a profoundly elitist view of the world.
Okay. And
I don't mean to feel so strongly about this, but...
you don't need to apologize for your feelings or your sentiments. That's why you're here, to share them with us.
Sure.
And then I wanted to sort of, related to some of the policy and legislation we're discussing, ask about your bill, which is part of the Right to Know Act. And I'm wondering, if you could tell us a little bit about how you plan to proceed with this.
Look, we're going to continue building support in the City Council. Are the obstacles daunting? Yes. But the Community Safety Act did not pass overnight, and neither will the Right to Know Act. The Right to Know Act, like the Community Safety Act, is going to be more of a marathon than a sprint. And we're playing the long game. Councilmember Reynoso and I are playing the long game. The coalition that's driving the legislation will not disappear. We're not snowflakes who are going to melt at the request of Bill Bratton. We're intent on passing police reform in this city.
And do you think this needs to be done through legislation, or do you think it could be done through sort of negotiated agreements with the police department?
Well, negotiation requires good faith on the part of a commissioner who should avoid disparaging the city council. But my concern about administrative change is that it can be reversed at will with the next administration. And so if you want to enshrine change, if you want to protect it from the vicissitudes of politics, the best approach is legislation rather than administrative change.
And I know Councilman Reynoso has said he wouldn't anticipate overriding a veto on his portion of this act. Is that a sentiment you share, or what are your thoughts on that?
As far as whether...
For your legislation.
As whether it would elicit a veto?
If there was to be a veto, would you be, because I know he was close to the 34 co-sponsors, right?
We would keep pushing.
Okay.
You know, it's a sensible piece of legislation. What we're requiring is that officers identify themselves and explain the reason for an encounter. I mean, if you were to ask the average New Yorker, do you believe you have a right to know who's stopping you and why you're being stopped? Almost everyone would say yes. I mean, that's a sensible reform to everyday encounters between police and civilians. So why would that be worthy of a veto? It baffles my mind.
If it were to come to that,
Yeah.
would you be interested or anticipate working to override a veto?
We're intent on passing legislation. And it's not only Councilmember Reynoso and myself, there's a coalition of stakeholders who are relying upon us, who have entrusted us with these bills, and are expecting us to pass them. You know, we've made a commitment and we intend to honor it.
And the other thing I wanted to ask is sort of amid all of this, police policy reform discussion and some legislation and just policy changes, if you feel that prosecutors and courts are currently playing an oversight role, and if they're prepared to take on more monitoring requirements.
Look, I mean, we are in a liberal democracy, constitutional republic. The legislature enacts a law and the system has to adjust. You know, when the Supreme Court established Miranda, there were many who thought that that would be unduly disruptive. But what might seem like a controversial proposal in the beginning becomes embedded over time. It becomes embedded in the day-to-day practice of policing and in the practice of the criminal justice system at large. So there's no reason to think it would be any different with either identification or consent to search.
Councilman Ritchie Torres, thank you for joining us.
It's an honor to be here, despite my lack of private sector experience.